it's interesting to see that the person, if indeed, as a country, our commitment is to fight illegal mining, and anyone involved in illegal mining is punished. The person who admits undertaking the illegal mining is rather used to punish someone who was not directly involved, but he had the concession. Then one begins to ask the question, really, what was the intention, what was the motive, and why is Wontumi the one behind bars at this time round?
I think the NPP as a political party failed Wontumi. And they are hiding that failure by trying to shift the goalposts to other people. If you look, when the matter went before the High Court judge in 2nd D, Samatex won against Wontumi. And the High Court judge in 2023, not 2026 or 2025, the High Court judge came to the conclusion that Wontumi had trespassed on Samatex concession and were engaged in illegal mining.
Engaged in illegal mining?
Yes.
Abusia chama Wontumi case no say and the case no ehia Lawyer Edudzi Tamakloe will throw more light on the case. Mede emu entremu ebema sanso na Honorable Fiifi Boafo ono so wakasa e dia fasa case no. Eho mesrew se ubenya abotre mede mu ntremu ebebre na ansa na yebeto aso no mesrew se wonya unsubscribe ya no subscribe e dia ma like video wi na shema wonya bi no nso onya bi ehwe. Menua yenko case no eso Edudzi Tamakloe a wo ye lawyer na wo san so eye NDC member o chiremu a chairman Wontumi case no a enam so nti amaya jenu no eye NPP4 na amwa chairman Wontumi because somewhere 2019 and 2023 satamono na NPP aban no na ewo ho but sama boy ewo no company bi ewo ho a ye from Samatex omo adwuma omo eye enua ho adwuma but omo concession bi a ewo ho omo de chama Wontumi ekogina court somewhere 2023 so omo asase omo yes woduma no chama Wontumi aba asase no so enti omo enti ase na omo de chama Wontumi kopie mu ewo court but asam no kopie mu court no judge na wotena asam no so oye ne hwehwe mu no ohun se chama Wontumi kura no dwuma na wo ye no ho no enye legal mining na oye but ebum eye illegal mining na oye but insan says atam no na MPP na ewo aban mu nti no omo ampia muwa na chama Wontumi of course so eye na adwuma but na NPP4 be say omo betena aban mu for the rest of their lives and a full fear so and water and as ye or more free aban and se mo free aban mu na sa ban bia ba na sa ba hwehwe Wontumi krata mu na so wo se Wontumi adiboni bi na sa Ghana mra twe Wontumi aso a dede bebrebe efri hen enti lawyer Edudzi Tamakloe aba be kire na bi e dia fa Wontumi the case no wadi nkomo bebrebe e dia ka ho ti mesrew se ubenya abotle mema wa hwe ni video no na wo so udwia akọ comment section ho na wotimi akire wa bi sanso na Fiifi Boafo a wono so wo ye NPP communicator wono de wo se asemwi odwe hu a wonti ase se memeti efie bi mu na mafre obi se bra na mensoma ko wia obi ade bremi o ko yero ya chew se wo na wakọ wia ade no but ensan se me na mesoma a wonti na ya chemi agirimi na wo a wokọ wia ade no na ya jawo free senant ho in disasem we Ghana for bodwe hu a woti ase ana but ni nyina mu no enu achi mehwe lawyer Hamza Suhini na wo kan sembi sasa Mr Ogun no na asem no ne ntie mo bujaro no ono no wanye challenge wo genefum so etumu enti punishment bia na wo so mo de ma no omo de ma no enu ti na ono no yamfa no ko gina court ba wo hwe chama Wontumi a ono na wo genehudi se owone krata enunti na wo ye adwuma e wo sama boy ho enunti na omode no ekoko gina court na attorney general wone no edi asem no ense Wontumi wo se wo nkrata na se court so kire se adwuma na wo ye no ho no eye illegal mining na wo ye dia na kire se Wontumi ono ankasa challenge na ahyase no oye ye no na wanyi ne fumso antumu no enunti na ma Wontumi wakwakodamu no enti Mr Fiifi Boafo ono de or your NPP communicator. But one thing I'm actually so Ghana people have any say NPP, our bam, na se NDC ni bi eye bone na se ye chena na kire se MPP fo ni nyina ebe attack ekoba sa nso na NDC fo na ya chi o munipa no na o mu defend se waye bone se waye papa uti o communicators na o mu nyina na ase dey defend sa nso na se NDC eba be mu na se MPP ni bi koye bone na se ye chena na koye se NDC fo attack na MPP fo so defend enti when na ye na ye beti ye ho ase na ya gya tum se bone eye bone no matter your political party na papa nso eye papa no matter your political party but se ko ba say ya na obia kire na bi nua me ma me kasa enye tintin o mu video no ewa kakra ye nkona ye nkotie ensem a Mr Fiifi Boafo any lawyer Edudzi Tamakloe na no de be ka say why expose Wontumi big time because me am tie na me nim say Samatex kura mo de Wontumi ko gina court e ma Wontumi e di sa asem no ho fo e ma ye kan say illegal money e na oye mesro so be nya botro no hwe video no e de kwakosi awie na wo so say semi e wo ha Wontumi ati wo ho ase na comment bia da wo no na wa comment section no wa twene ni na e de go amame like bibi na share mo bi no so kunya bi enhwe bera wase yankobo nshira e video.
It's interesting to see that the person, if indeed as a country, our commitment is to fight illegal mining, and anyone involved in illegal mining is punished. The person who admits undertaking the illegal mining is rather used to punish someone who was not directly involved, but he had a concession. Then one begins to ask the question, really, what was the intention, what was the motive, and why is Wontumi the one behind bars at this time round? They do not want us to believe that, well, Wontumi was the target, and for every reason we had to get Wontumi incarcerated. But like I said, Wontumi as an individual reserved the right to go back to court. It does not lie with the Deputy Attorney General to say that whether he will succeed or not. It's a matter for the court to determine. So yes, the lawyers have perused the judgment and they are of the firm belief that that should not have been the ruling, and for which reason they want to go to court to challenge the ruling that was given. Beyond that, if you say that there is no justifiable cause for Wontumi to go back to court and appeal, the question you need to ask yourself is that what do you expect from the Attorney General? The Attorney General went to court, and then he was expecting that Wontumi will be jailed, and indeed he got that. So the same person, if you're appealing against a ruling he has secured in court, definitely he would protest and say that, well, he does not believe that Wontumi will get it. So I do not want us to rely on what the Attorney General is saying, because yes, for him, what he was hoping for, what was praying, is what he got from the court. But the lawyers have said, one, that there was no evidence to show that Wontumi indeed gave an assignment to the gentleman who was believed to be mining on his behalf.
You mean there was no documentary evidence?
And it's a legal question, because as to whether or not to have assigned interest in a concession to another person, it is not, and this was a situation where it was Wontumi's word against that of the gentleman who was mining on his behalf. There's no documentation. Just as the court, the authority, the minister, assigned the lease to Akonta mine, same was expected if he was also assigning the lease to another person. Was there any evidence to that effect in court? That was not adduced during the hearing. Beyond that, they said that the guy was mining for Wontumi. I am not sure that the evidence produced was enough to justify that indeed Wontumi asked him to do that. Wontumi has asserted that for him, he asked him to perform a specific function. And what the court is concluding on is not what he did. But like I said, it's a matter for the court to determine. And they have the right to proceed to court. We wait to see what the court will say. As for those who are of the strong belief that, well, Wontumi indeed is guilty of the offense he was charged with and for which reason his incarceration was right. It's an individual position you have to take, and then I respect that. But we'll wait to see what the court will say after the hearing.
Yeah. But at the end of the day, Edudzi, the point is that if you listen to lawyer Atachia and then also the concerns that have been raised by his previous lawyer before Atachia came in, you would find that they all seem to agree that there seemed to be not enough evidence for that conclusion to be drawn by the judge, as we saw in the judgment. And so putting all the circumstances that was aggregated, accumulated to draw that conclusion was wrong. And so for an appeal process, they should be successful, they say.
Okay, so the success or otherwise on appeal would largely be based on the grounds formulated, the nature of the evidence that were put before the trial court. And the first principle that we must all agree is that appeal is by way of rehearing. So the three appellate courts are put in the place of the trial judge. So they will be going through the trial as though they were the court of first instance. But just that in this case, they don't have the benefit of evaluating demeanors and all of those things. They will be looking purely on the record. Yeah. Then, based on that, they will be making, so like the lawyers will say, appeal is by way of rehearing. So they will be put in the place of the trial court. But you see, I've heard a lot of comments, particularly on this Wontumi trial. And I think that we need to do a bit more of critical thinking on these issues. You see, look, I think the MPP as a political party failed Wontumi. And they are hiding that failure by trying to shift the goalposts to other people. Why do I say so? The first time that this Wontumi matter became a matter of public conversation was by the Minister for Lands and Natural Resources under the MPP, who first raised the issue that Akonta mining is engaged in a forest without the necessary authorization. That should have been a red flag for the MPP. This is your original chairman. This is what he does. It is your collective responsibility to ensure that he does it right. You failed him. And instead of taking responsibility for that failure, you are looking for judges. You are looking for people to blame. No. Look, if you recall, this same Samra boy and Tano, Akonta mining and Wontumi in particular, if you call the 2013 incident, where he accused that the previous Mahama administration, officers of state had destroyed his mining concession and other. When the MPP came to power, he decided to issue a writ to challenge that process. The matter went before my Lord Justice Ajay Frimpong. At that time, he was a justice of the Court of Appeal. Now he's a Supreme Court judge. When he evaluated the entire evidence, he came to the conclusion that whatever the state agencies did at that time was lawfully carried out. It didn't end there. 2023, Samatex, you know them?
Yeah, very well.
You know Samatex? Wontumi went on to Samatex forestry concession and started mining. Samatex issued a writ against Wontumi for trespass onto their concession.
In a civil
matter. I'm just giving you a pattern of conduct. The matter went before the High Court judge at 2nd D. I still remember, I think I have the case. If you look, when the matter went before the High Court judge in 2nd D, Samatex won against Wontumi. And the High Court judge in 2023, not 2026 or 2025, the High Court judge came to the conclusion that Wontumi had trespassed on Samatex concession and were engaged in illegal mining.
Engaged in illegal mining?
Yes. I just want to read portions of the judgment for you.
Samatex versus Akonta.
Yes. So this is the decision in the High Court of Justice, Western Region, held at the 2nd D on the 19th day of May 2023, before her ladyship, Efia Edu Amankwa, Samatex Timber and Plywood Company Limited versus Akonta Mining Services. This is the decision of the High Court. And if you look at the 16-page judgment, he said, even though the defendant has acquired the mining right to subject Samurai Boy through the mining lease agreement between the government of Ghana and the defendant, blah, 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 that mining lease is invalid. In the circumstance, the defendant counterclaim is dismissed. That is Wontumi.
But Edudzi, not to interrupt.
Look, I'm coming. Please, I'm coming. At that time, Wontumi claimed that he should be given damages for all based on that counterclaim. The High Court judge found him and invalidated the supposed lease. This is Samatex. Then came the decision of Akonta Mining versus the Minister for Interior, Defense, among others. That again, the court found that Akonta Mining had engaged in illegal mining.
This is just a question.
But you see,
it's a question for you to clarify.
Please go ahead.
So I have not read this judgment.
Please, I will share with you later.
Based on what you just said, I'm only asking the question. Is it also not the case that Wontumi went on or Akonta Mining, because the company is a distinct personality from Wontumi as an individual? Were they not also claiming that indeed a lease had been given to them and the lease covered that portion of land, so for which reason he did not just enter on that plot of land as though he just decided to do so without a lease? Is that not what his contention was at the time?
See, at that time, the concession was that Wontumi had failed to comply with the laws of this country for whatever he's doing. Mining is regulated. You can't just wake up and say, I'm going to mine. Yeah. So the point I am making is that they had been consistent. In fact, they had been...
I was only asking the question. Did he have a lease for that portion of land?
The court said it was invalid for whatever
but he had a lease.
No, but the point is that...
he was not just somebody who had decided to go and then disregard the law.
I am making this point. I am making this point because, you see, 2019, my Lord Justice Ajay Frimpong had ruled against him, the same mining activity. 2023, the same High Court. So I am making the point that even prior to this judgment, there were subsisting judgments of the High Courts of this country against the company that you people knew, but took a certain posturing. Sometimes I have the feeling that you guys felt you will never lose power.
Yeah.
And therefore, there was a certain level of impunity with which you handle some of these undertakings. Look, I remember when Akufo-Addo appeared before the Catholic Bishop Conference in Akufo-Addo and made the point that as far as he is concerned, as at the time you were speaking, Wontumi was not engaged in galamsey, that for me should have been a red flag. Look, this morning I heard you make the point that, listen, the basis on which this judgment came, circumstantial, there was no direct evidence and all of those things. You are a lawyer to me, so you are a lawyer, I'm a lawyer. The first thing we are taught in the law of evidence class is that there are two things every lawyer looks for: the burden of proof and the burden of persuasion. These two things. We know that in criminal trial, the burden of proof is on the prosecution and is proved beyond reasonable doubt. But we also do know that within this burden, there is also a burden of persuasion. That burden of persuasion is not fixed. It oscillates. It moves from parties to parties.
At which point, or the instance of...
Okay, so the point is that in a trial like this case, when you make a positive assertion, the burden is on you to prove. That's persuasion. So where, for instance, you make the claim that I brought Henry Oku onto the concession only for reclamation, who bears that burden? Counsel, oh, my brother.
but so he,
Because you see, at that point,
he brought the gentleman for a specific
and that is
duty.
what
That is
why I asked that. So the
That's what he said.
So the burden was.
So if you disagree,
wait.
I'll allow you to proceed. If you disagree, he says that, well, I brought him to come and do reclamation. If you disagree, the burden is on you.
No. First of all, no.
How?
No, the burden doesn't shift.
It is you who is alleging that the person was there for different purpose.
In order for us to reduce the interjection, let's see.
I don't intend to do that.
You see,
Counsel, you have 2 minutes.
I will
more
finish with that. You see, in this particular case, you came and said, in fact, if you look at, and let me read Chairman Wontumi's paragraph 8 of his witness statement that he gave when he appeared before the court. I just want to read that portion, the paragraph 8, if you permit me. And like we always say, nothing convicts a man faster than his own words.
And this was under cross-examination?
No, the witness statement that he offered. And this is why he said, paragraph 8. I wish to state clearly and unambiguously that the permission I granted to Mr. Henry Okun was strictly and exclusively for the purpose of land reclamation. Specifically, the planting of cocoa seedlings on the already mined and degraded portions of A3 concession. I did not at any time grant Henry Okun permission to conduct, undertake, or carry any mining operation or to extract minerals from A3 concession. The permission I granted was limited solely to reclamation activities on the mine out portion. That's your bare assertion, bare words. Now the man, Henry Okun, you are saying that it shifts to him. So the man now comes and say, Chairman, this is not what we agreed to do. What we agreed to do was that, one, you are not giving me any money for reclamation. I will mine. And the portion where I went on to were on the unmined. You only reclaim that which had already been mined.
Yeah.
So you cannot be talking about reclamation when the place you asked me to go is the unmined portion. That testimony was never controverted.
Yeah.
That testimony under cross-examination was never controverted by Wontumi's lawyers.
So it's
under cross-examination.
So it gives a cause for.
So it leaves it hanging. So what it means is that even if it's on oath by oath,
no cross-examination.
Yes,
on appeal, it's just the record. That is that. So that is why I'm making the point that when you go on appeal, that is the only thing. Then now the man says that, Chairman, you know reclamation is expensive. Did you give me any money for reclamation? No, because you wanted me to mine to pay. So where can pay arrangement? All these things are in the testimony. That is why when he brought the Western Regional
Minister,
the former Western Regional Minister, as his prosecution witness, under cross-examination, a simple question was put to him. Were you there? What would be his answer? Definitely not. You were just the chairman of RECSEC. So the point I am making is that if you read throughout the case point by point, you will notice that there was a simple case of failure